for yesterday's session will be sent to you. We shall be starting closer to 5:30, but we'd agreed to start now, and we are going to start. Right. We spoke about summons. Now you get different types of summons. And a summons is how you commence legal action in a civil case. You get what is called a simple summons, and a simple summons will contain the particulars of claim in the summons itself. You also get what is called a combined summons, and a combined summons is accompanied by particulars of claim. Because there is too much information to put into a simple summons. You need to, in a combined summons, or together with a combined summons, attach particulars of claim in which you set out your cause of action. And there are certain jurisdictional facts which must be contained in your particulars of claim to establish a cause of action. There's no case in law that does not deal with facts. So there must be actual facts, a story that tells you how the case arose. And that's where the term, or rather the term is derived from cause of action. What is your cause of action? It is to be contained in the facts in your particulars of claim. Now, in your particulars of claim, according to Rule 5 and 6 of the Magistrates Court rules, have to contain specific allegations or specific details or particulars. Starting with the parties, the plaintiff is described, the defendant is described. If there's more than one plaintiff, each plaintiff must be described individually. And we dealt with how those parties are to be described, as well as, and this applies to natural persons as well as juristic persons. They must be described adequately. Persons, their full names preferably. Alternatively, if you don't know their full names, their initials, but try by all means to get the full particulars or the full names of the person concerned. And I illustrated that if you want to serve summons, if you are suing Mr. Johannes Jacobus van der Merwe, and in your summons you don't know his first names, you put JJ van der Merwe, and the sheriff gets to that household to serve the summons and asks for JJ van der Merwe. 8 people respond that they are JJ van der Merwe. You as a plaintiff are going to have problems, because which JJ van der Merwe are you looking for? Or are you suing? So you've got to make sure that you obtain the full names of the person whom you intend to make the person suing and to sue. After all, you should know the full names of your own client, and you should not be using their initials. You also need to allege in your particulars of claim that the court out of which you are issuing summons has the necessary jurisdiction to hear the case, to entertain the case. Then what must follow are the facts on which you rely. And they normally start with a date. On the 10th of August 2022, and at Constantia, Cape Town, the plaintiff sold to the defendant, and the defendant bought from the plaintiff a motor vehicle, a Mercedes-Benz 230E 1979 model. If you like to describe it even more, you can say it was orange or blue or pink or whatever the color was. More detail is important when you are describing things. But you must be careful in your particulars of claim as well as your summons not to plead evidence. Your action by way of summons is also the legal proceeding in which oral evidence of your witnesses will be called. And one of the reasons you choose to follow the action route is because you anticipate that the person whom you are suing is going to dispute the material facts to your case. In other words, they are going to raise a defense. When you consult with your client, you must be able to discern from that consultation that the defendant is going to defend the action and what could possibly be their defense that they will raise. And when you consult with your client, the plaintiff, before issuing summons, you ask your client, if you are not able to discern from the facts, whether they think this person will defend this action. Because if they do defend the action and there are material disputes of fact, the case will have to go to oral evidence in the action in any event. But if you decide to go by way of application, which is the evidence is on affidavit, and it transpires at some stage that there are material disputes of fact, or even one material dispute of fact, then the magistrate will refer that portion or the actual case for oral evidence, either on everything or on specific aspects of the case only. And what you need to watch out for is if you do make that mistake of suing by way of application instead of summons, you as the applicant will be ordered by the court to pay the wasted costs of that application. And the courts will say, you, and they may even say you, the legal representative, gave your client, the applicant, wrong advice by telling them to go the application route instead of the action route, and may order you, the legal representative of the client, to pay the costs, the wasted costs of going the application route. Yes, this is where ethics come in once again, and professional conduct. The conduct such as what I've just described now may amount to professional misconduct, and the Legal Practice Council may even institute disciplinary proceedings against a legal practitioner who is found to have given his client or her client incorrect advice, because you are presumed to be, by virtue of being admitted as an attorney, a competent practitioner that gives your client sound legal advice. So be careful, read, research, prepare yourself at all times. One more thing, before you institute any proceedings, even if you've decided you are going the action route or the application route, you should at that point already have done your research to see if the law is in your favor. If there is a case that was decided in your client's favor, and if the law is on your client's side in respect of that particular cause of action. You don't do research at the end of the case when you are going to court to argue the case in the application or to do your closing arguments only. Not at that stage. You should do it before you even institute legal proceedings on behalf of your clients. So you have to constantly read. If you don't like reading, then the legal profession is not for you, because here we have to read to arm ourselves. Without knowledge, you cannot go anywhere. You cannot do anything for your clients. So it's imperative that you love to read. Not necessarily love, but you have to read when you have to read. After you have then stated in your particulars of claim the facts upon which you rely for your cause of action, you have to, in terms of the legal principle involved, plead that the defendant has breached, let's call it the contract between the parties. In other words, there was default on the part of the defendant, or there was wrongfulness or recklessness or negligence on behalf of the defendant, which caused the plaintiff to suffer damages, be it by way of contract or delict. But you have to make the allegation that there was this breach, and as a result of this breach, the plaintiff has suffered damages. These are the damages that the plaintiff has suffered, and you are required to, in terms of the rules, quantify the amounts for the different types of headings of damages. And the headings of damages or heads of damages may be classified into 1, general damages. These are normally damages for pain and suffering, loss of amenities of life, and so on, which a plaintiff may have suffered as a result of the breach. Then you also get what is called special damages. Now, special damages are specific, like emotional shock and trauma. Okay, that is part of general damages too, I apologize. But your special damages will include heads such as loss of income. If for whatever reason the breach has caused the plaintiff not to be able to earn an income, to work and earn an income. One of the special damages the plaintiff may claim in their particulars of claim can be loss of income. Another, or loss of support if it is somebody claiming on behalf of a dependent. Another head of damages is past medical expenses. If as a result of the breach or negligence of the defendant, the plaintiff has suffered past medical damages, medical expenses, because they were in hospital or they had to go to the doctor, they had to go see specialists, you will keep those receipts and you add them up, and then you write in your particulars of claim the amount which you are claiming in respect on behalf of the plaintiff in respect of past medical expenses. And also you attach the invoices as proof. Then lastly, you also get what is called future loss or future medical expenses. And those future medical expenses will most likely be calculated from the reports of expert medical witnesses, doctors, specialists, occupational therapists, industrial psychologists, psychiatrists, plastic surgeons, reconstructive surgeons. The list is endless. There are just so many experts which may be used to calculate or to determine and calculate the costs of future medical treatment, depending, of course, on the nature and extent of the injuries suffered by the plaintiff. And then lastly, in your particulars of claim, you must also say, if you are suing for damages, that the plaintiff holds the defendant liable for payment of these damages.
Nakedi?
Nakedi, can you please mute for us? Thank you. If it is a claim against, if you are issuing summons in respect of a claim against an organ of state or a government department, you have to, in your particulars of claim, specifically allege that you have complied with the provisions of the Institution of Legal Proceedings Against Certain Organs of State Act, number 40 of 2002, by delivering your notice or Section 3 notice or your letter of demand to the defendant in the prescribed manner, by delivering same to the National Commissioner of the Police, to the Provincial Commissioner of the Police, and to the Minister of Police. And therefore you have complied. Here is a copy of the letter and proof thereof that it was sent to, that it was delivered in terms of the Act. And you attach the copy to your particulars of claim to complete your cause of action. Lastly, then you say in your particulars of claim, wherefore, and sorry, one more thing you need to say after the demand is that despite the plaintiff having given the defendant due demand for payment of the amount claimed, the defendant has failed, refused, and or neglected to pay the amount claimed or any amount at all. And then lastly, you ended off by saying, wherefore, the plaintiff claims, the plaintiff prays for judgment against the defendant for 1, payment of 12 million rands. But remember, we are in the magistrate's court now, so it's either payment of 200,000 rands or payment of 400,000 rands if it's in the regional court. Number 2, interest on this amount at the prevailing prescribed rate of interest from date of demand, if it is a state organ, or from date of summons, if it's not a state organ and there's no need for demand, until the date of final payment. I've seen some people write until the date of payment. What if the defendant pays the amounts, the total amount in installments? Then the plaintiff will be left with a problem, because it doesn't say final payment. If they pay the amount in installments, interest will run until the date of the first payment. Therefore, after that date, the plaintiff may not be entitled to interest if one wants to argue it on a technical basis. But just to make sure that you don't encounter that problem, rather say until date of final payment. Okay, that was any questions?
But I have seen a summons a while ago where in the relief, final relief that the attorney served in this particular stuff claim, he actually asked for costs on an attorney-client scale, and then he elaborated on the cost. Was the magistrate's court summons, where he then said, and the cost will be calculated as follows. I'm an attorney with right of appearance in the High Court, so I'm entitled to a higher fee. And because it's a prayer, we could not really respond to it in our plea. How do one deal with that? I do not believe it is correct for him asking the court to put themselves in the position of a taxing master. I was just wondering, while you were talking about the relief and the final prayers, what is your comment on that?
Yes, thank you for that question. I forgot to say, you reminded me now, I forgot to say, after the issue of interests, you then ask in your prayer for costs of suit. And that is normally interpreted by the taxing master to mean costs on a party and party scale. If a plaintiff or a plaintiff's attorney asks for costs on an attorney and client scale, they must be able to justify it. And a reason such as they are attorney, they have a right of appearance in the High Court, is not sufficient for attorney and client costs. Attorney and client costs are either provided for in the agreement, which the plaintiff relies on in their cause of action, or in any other document that was agreed to between the parties. A party cannot ask for attorney and client costs because they are admitted or they practice out of the High Court. It's not sufficient reason. Coming to your question with regards to how to plead to that. When you plead, and I've noticed that many practitioners don't plead this, they don't plead to the prayer. They don't plead to the prayers. They just leave it. They just say, wherefore the defendant prays that the plaintiff's claim be dismissed with costs. It is a pleading. The prayer forms part of the pleading, and you are required to actually respond thereto. And your failure to respond can be viewed as you admitting that they are entitled to it. So you've got every right in your plea to plead to the prayer by saying, I deny that the plaintiff is entitled to payment of 200,000 rands for the reasons pleaded above. And then you say, ad prayer to the interest, in the event that the court finds that the plaintiff is entitled to the relief in number 1, I admit that the interest rate will be calculated at this rate. Number 3, ad prayer 3, I deny that the plaintiff is entitled to costs on an attorney and client scale. There are no exceptional circumstances for an order for an attorney and client scale, and also there is no misconduct on the part of the defendant to warrant the court awarding costs against the defendant on an attorney and client scale. What is the difference between pleadings and a prayer? Khanyago wants to know what is the difference between pleadings and a prayer. Cora, would you like to answer Mr. Khanyago there?
Can I try, Ed?
Yes, please.
The pleadings is where you base your cause of action on, and the prayer is what you hope to achieve from the court. Yeah.
Thank you, Quintus, for that answer.
If I can just add, pleadings will be your summons, your plea, your pre-trial notice when you're dealing with, and maybe a replication if they replicate to the plea, that will be regarded as your pleadings in a summons action. When you're dealing with applications, it will of course be your notice of motion and your application, your answering affidavit and your replying affidavit. That is my view of what pleadings are. Prayers are what you ask the court, what do you want? That is the relief that you want.
Thank you, Cora and Quintus. Khanyago, so prayers have got nothing to do with church and God in this instance. It is what you want the court to give you, the relief that you want. Either you want payment or you want an interdict granted in your favor. But your prayer forms part of your pleading. And I'll make an example. Your particulars of claim accompany your summons, your combined summons. And it is called a pleading. Your particulars of claim are called a pleading. And at the end of your pleading, which is your particulars of claim, you ask the court, now you pray to the court to give you the relief based on what is contained in the pleading. The same applies with the plea. Your plea is also a pleading. And in your plea, as the defendant, you will pray at the end of your pleading that the plaintiff's claim be dismissed. In your replication, which is also a pleading, you will also pray. And here you will pray that the defendant's plea be dismissed with costs. In an application, now in your application, your pleadings are made up of your notice of motion and your affidavits. At the end of your affidavit, you will have what is called also a prayer. But in this case, because it's an affidavit, the deponent will say, in the circumstances and for the reasons stated above, I respectfully submit that I have made out a good case for the relief sought, and I accordingly pray that the court grants me the relief sought in my notice of motion. I don't know if that makes sense to you. Khanyago, if you can give me a thumbs up, I'll be happy that you are happy. Okay. Good. So Khanyago is happy. Thank you. I'm happy then. Let's move on then. In different causes of action will have different jurisdictional facts which you need to plead in your particulars of claim. For instance, in a delict, and as I've illustrated earlier, you will have to prove wrongdoing on behalf of the defendant. This is now as the plaintiff. You have to allege that the plaintiff did wrong. Right? Because a delict is a civil wrong done by one person against another. Tolagele, sorry, we don't do page numbers here. Your colleagues may answer you, but I don't do page numbers, sorry. Anyone who knows which page we're on can answer, Tolagele. But your delict, your jurisdictional facts will have to be different. In agreements or contracts, your jurisdictional facts will still be different as well, because you will base your cause of action on something else. Then, where you are relying on a check, a bond, a loan agreement, or an acknowledgement of debt, your particulars of claim will be different as well, because you need to allege different facts in support of your case or your cause of action. The same would apply to estate agents' commission. So you've got to look out for those things as they are to be pleaded. There's a very good book called Aimler's Pleadings of Precedence. Aimler's Pleadings of Precedence. I'm just writing it down here for you to see that you can get yourself a copy of it. There's also another one by Van Blerk. Van Blerk also has a good book, and I stand corrected. Yeah, I don't remember the name of the book, but I think it's Precedence of Pleadings by Van Blerk, but I may be wrong. I just don't remember. As soon as I remember, I will let you know what the correct name is of that publication. But those are good publications in that they deal with the most common causes of action in both civil and criminal cases. Some criminal cases, not as much, but it's more based on civil precedents. They also tell you, and this is also very good for drafting heads of argument, because they tell you which cases are the leading cases in those legal principles involved. So it's a very good book. I use it, or it's on my desk right now because I was doing something earlier today. So I swear by this book, and I would encourage anyone who wants to become a litigation specialist to acquire that book. And by the way, one more thing. When you started at university, your law studies in your first year, I hope you did not fall into that WhatsApp group that sold your books at the end of each semester or when you got your results. Law books are not to be sold. You may have had good reasons back then, but now is the time for you to start collecting books. If a client walks into your office as an attorney and they don't see a single book, believe me, they will start shivering. They'll be worried because our tools are our books. That's where you find everything. A good lawyer does not know the law, all of the law, but a good lawyer knows where to find the law. And you'll find that you will need to sharpen your research skills to be able to find out, to be able to find the law, the relevant law. And when you do research, you must research the most recent law, the most updated law, and the same applies to case law. Same applies to case law. You must know the most relevant cases. I was once involved in a case, and the day before the case, the Constitutional Court handed down a judgment which swung the case in my favor. And because I had prepared until the day before, day of trial, actually, I came across this case, and my opponent, it turned out, was not aware of this case because he stopped preparing for court 2-3 days before court and not the day of court. And the judge was also impressed because the judge was also not aware of the case. So it's important for you to go and read up, to prepare until the last minute that you have before your case, so that you know which case law will apply. All right, so yeah, prepare, prepare, prepare. If you fail to prepare, then prepare to fail. Right, we are now going to move on to defendant actions. We are still dealing with the summons. So now we need to know what happens when that summons gets defended.
Today.
Is someone saying something? Zuki?
No, sorry, advocate. I'm not saying anything. Sorry.
Okay. Oh, your mic was on. Okay, I thought you would say something. Right. So now your case becomes defended. The defendant decides, but wait a minute, I'm being sued in this summons wrongfully. I'm not the one who's liable here. I need to defend this case. Or I've got a good defense. But your defense must be a bona fide defense. What's bona fide? Good faith. In other words, a genuine defense. Not a made-up defense, but a genuine defense to the claim against you. Your attorney will then consult with you, should you decide to instruct an attorney to represent you in this, to defend this case. And the first thing the attorney will ask you, or the first thing you must ask as an attorney, is you must ask your client, do you have a defense to this case? Do you have a defense to the claim against you? And if your client says yes, you ask, what is your defense? They give you the defense. It's up to you now, the attorney, to discern whether the defense is a bona fide defense. Because if it is not a bona fide defense, you are going to lose the case. And what's the use in defending a case if you don't have a bona fide defense? You are wasting money. And that is exactly what the plaintiff is going to say. If you as the defendant now defend the case, but you don't have a bona fide defense, you file a plea, and from your plea, it is established or it is not established that you have a bona fide defense. If it is a claim for damages for a liquidated debt, And a liquidated debt is an amount that is easily ascertainable or established in the rand. Then the plaintiff may bring an application for summary judgment. And the summary judgment application will be premised on the following. 1, you have entered appearance to defend solely for the purpose of delay. Number 2, you do not have a bona fide defense. And as a result, the court must grant the plaintiff summary judgment against the defendant in the circumstances. And if the court agrees with the plaintiff that there's no bona fide defense, the court will grant summary judgment against the defendant in that case. There's a hand.
Advocate Pitt, I would like to know, does the rule also apply in the Magistrates Court that you must file your plea before you can apply for summary judgment in the Mag Court?
Yes, it does. Do you agree with me?
Thank you very much. I was not sure about it.
Okay. What is your experience of it? Have you ever come across one?
I do not have experience in the Mag Court, but I do have some experience in the High Court. So that is why your lecture is actually extremely important for me and quite exciting.
Okay. I'm glad that you are actually enjoying it. All right. Does anyone else have knowledge of the situation in the Mag Court with regards to summary judgment? Okay, well, we're going to get there soon. We're going to deal with it shortly. Let's go there right away. Summary judgment is in terms of Rule 14 of the Magistrates Courts Act. And it says that the plaintiff may, after the defendant has filed a plea, apply to court for summary judgment on each of such claims in the summons as is only on a liquid document for a liquidated amount of money, for delivery of specified movable property, or for ejectment, together with any claim for interest and costs. So within 15 days of the service of the plea, the plaintiff shall deliver a notice of an application for summary judgment. The plaintiff shall verify the cause of action, the amount claimed, if any, and identify any point of law relied upon. I'm just checking something here. Don't worry about the awkward silence. The plaintiff shall, in the affidavit referred to, verify the cause of action, the amount claimed, if any, identify any point of law relied upon, state the facts upon which the plaintiff's claim is based, and explain briefly why the defense as pleaded does not raise any issue for trial. And if the claim is found in a liquid document, a copy thereof, the defendant may give security, satisfy the court by affidavit, or with the leave of court by oral evidence of any other person who can swear positive that the defendant has a bona fide defense to the action, and such affidavit or evidence shall fully disclose the nature, grounds of defense, and the material facts. Cora, you know, you've actually asked, you made me ask a question too now. I'm also a High Court litigant, and I was not sure, I'm not actually aware of what the situation is in the Magistrates Court. So I take that back. I will look it up and I will come back to you on that one, okay?
Thank you,
All
Advocate
right.
Pitt.
What is the difference between a summary judgment and a default judgment? Summary judgment is, as I've just explained now. Okay. Quintus, Martin, and Motswagai have volunteered answers to your question. Summary judgment occurs when the defendant filed a plea but failed to defend timeously. Okay, I think that's failed. Default judgment occurs when the summons has been issued to the defendant and the defendant did not file a notice of intention to defend and you want to get speedy judgment. Okay. A default judgment is granted without hearing the arguments of the party against whom it is granted, usually followed by a warrant of execution. Okay. Janus then says summary judgment is judgment based on a liquid document. Default judgment is judgment that may come about when the defendant has not entered a notice to oppose. And then Cora says default judgment, there's no appearance to defend served. Okay, it's no appearance to defend served, as well as no plea. Default judgment, a plaintiff may apply for default judgment where a defendant has failed to file a notice of intention to defend within the time required to do so. That is why it's called default. The defendant has failed, has defaulted to defend the action. Also, the plaintiff may also apply for default judgment where the defendant has filed a notice of intention to defend, but has failed to file a plea within the required time. That is default judgment. Summary judgment may be applied for in cases where there's a liquid document. The claim is based on a liquid document, a liquid amount of money, a liquidated amount of money. In other words, it's ascertainable.
Sorry, Advocate, do you mind repeating your the definition that you gave on summary judgment, as well as the one on the default judgment?
Who's that?
Heaven, sir.
Where were you when I explained it?
I was here in the class, sir.
Okay, you want me to repeat it? I'm still busy with the summary judgment one though.
Okay, thank you.
All right. Okay. I'm going to go back now to default judgment. I'm going to try and go slowly. All right. Default judgment. The plaintiff can apply for default judgment or judgment by default against the defendant where the defendant has failed to file a notice of intention to defend the action within the prescribed time. A plaintiff may apply for summary judgment against a defendant when a defendant has filed a notice of intention to defend So I'm going to have to start over again. Yeah. Then you say I'm a difficult person when these things happen. I'm sorry, guys, but this is unacceptable. Let's please try to adhere to one simple rule, just making sure that our mics are muted. A summary judgment application may be brought by a plaintiff when the defendant has filed a notice of intention to defend filed a plea, but from the plea, it is clear that the defendant does not have a bona fide defense. Or if the time for a plea has lapsed and no plea has been filed, but that claim by the plaintiff must be in respect of a liquidated amount. In other words, it can be counted easily, it can be established, or there's an invoice or a check or something that shows it. Or it is for delivery of specified movable property. Or lastly, it is for ejectment or eviction from premises. That is then the plaintiff may apply for summary judgment against the defendant. You need to look at the words that are used. Heaven, I hope I've answered you. If you need to look at the actual words used, default, the word default judgment. Default itself implies the defendant has failed. What has the defendant failed? Failed to file a notice of intention to defend. Failed to file a plea. That is default judgment. They've defaulted in doing those things. Summary judgment. Summary judgment is an expedient remedy given to a plaintiff to end the matter summarily. That's what summary means. Summary means quickly, expedited. So that's how you distinguish between the two. I hope I've answered your questions with regards to that. Rahima, your apologies accepted. Between a notice to oppose and a notice to defend. Okay, a notice to defend, right, or a notice of intention to defend, or an appearance, notice of appearance to defend. That one notice is used in actions only. Where there's a summons, you must file a notice of intention to defend. And the summons actually also states towards the end that if you intend to defend this action, you must file a notice of intention to defend within 20 days. It's 10 days or 15 days in the magistrate's court. So you are told in the note, in your summons, that you must file a notice of intention to defend in the action. In an application, which we will be dealing with later on, you have to file a notice to oppose. It's important that you get the terminology right. You defend an action and you oppose an application. All right. Let me see if there are any other questions there then. Failed for pre-trial and discovery as well, for example, where default trial is involved after you have compelled them to do same. Sandra, I don't understand that. What are you saying there? What are you explaining there?
Hi, advocate. Sorry with regards to default judgment or default trial. I know also you can get default judgment or default trial if they've failed to do or hold a pre-trial minute or issue their discovery affidavit. You can also compel them and get a default trial or default judgment. Okay.
Yes. Although it's a bit technical at this stage for what we're dealing with, but you're quite right to an extent. If the parties if the matter is set down for trial, and for some reason the defendant is not at court, the plaintiff may ask the court to grant default judgment against the defendant because the defendant has defaulted to come to court. Similarly so, if the defendant gets to court and the plaintiff is not there, the plaintiff may ask for default judgment against the plaintiff for dismissal of the plaintiff's claim. All right, so I hope I've explained that now. The difference between default and summary judgment. Yes, sir, there's a hand that's up.
I wanted to know, are you able to maybe give like a practical example when it comes to summary judgment? In what kind of matter would that happen?
Summary judgment?
Yeah.
in a matter where the plaintiff is suing the defendant for a check that bounced. It's a liquidated amount on the check. It's established, it's capable of being discerned from the check how much they owe. It's not a question of guessing how much they owe. It's established, it's right there. The check is a liquid document. The amount on the check is a liquidated amount. And then the plaintiff can apply for summary judgment if the defendant has failed to file a notice of, has failed to file the plea. Does that answer your question?
Yes, thank you.
My pleasure. All right. Let us now move on. Any other questions? Okay. Yes, Sasha.
Good evening, advocate. Sorry about that. I just thought about one question that I have. If, for example, someone has filed their plea and also filed a counterclaim with that, but then the other party does not file their plea on the counterclaim, what happens in such an instance?
Okay. Now, a counterclaim is normally a pleading by the defendant, where the defendant wants to sue the plaintiff also for something arising from the same cause of action. And I'll give you an example. The plaintiff sues the defendant for having for fuel sold and delivered. Now the plaintiff owns a filling station and sold to the defendant, who owns a trucking company with trucks, fuel. The defendant has failed, that is the plaintiff's claim, to pay its account for fuel for the month. Now, the defendant does not really have a defense to that claim because there's an agreement between the parties. There are invoices that were sent by the plaintiff to the defendant, and the defendant acknowledged receipt. Now, the defendant files its plea in which it admits that it is liable, but at the same time also institutes a counterclaim by way of a pleading, an additional pleading to the plea called a counterclaim, in which the defendant states the plaintiff and the defendant had a contract as agreed. However, one of the fuel attendants of the plaintiff put petrol into the truck instead of diesel, thereby damaging the defendant's truck. Wherefore, the defendant suffered damages and is now claiming an amount of 400,000 Rand for damages suffered by the defendant. The plaintiff then will have to file a plea to that counterclaim, because that counterclaim now constitutes a claim on its own. The plaintiff will be entitled to file a plea to that counterclaim. And in the plea, the plaintiff will either do one of four things: admit or deny, confess or avoid. Those are the four things that you may plead. And then at the same time, the plaintiff also has an opportunity to file a replication to the plea, the main plea. Have I answered you, Sasha?
Yes, thank you, advocate. But what if the plaintiff then, for example, fails to file their plea to the counterclaim? Then can the defendant then request judgment against the plaintiff then, or
Yes.
how? Okay.
Yes, The plaintiff can then apply for default judgment against the defendant can apply for default judgment against the plaintiff.
Okay, so then actually the roles reverse then.
Then they reverse, yes. The defendant now becomes the plaintiff in their claim, and the plaintiff becomes the defendant in the defendant's claim.
Okay, perfect. Thank you so much for answering that, Advocate. I really appreciate it.
It's a pleasure, Sasha. Richard Ali, I think it is.
Yes, thanks, Advocate. I just want to check with you. If you look at the action proceedings and the application proceedings, and if you go look at at the same time the default judgment and the summary judgment, how does the ex parte application fits into this whole process in the magistrate's court?
Okay, thanks for your question,
Thanks.
Richard. Okay, you need to first of all not look at an ex parte application in terms of application and action, right? You need to look at ex parte applications only in respect of applications. Remember, we are dealing with actions now, not applications yet. So when we get to applications, I will show you the different types of applications that you find in the magistrate's court. And ex parte application is one such application. And I'm going to make an example for you. In the magistrate's court, an ex parte application may be an application for the appointment of a curator ad litem to a person. No, sorry, wrong example, bad example, because you can only do that in the High Court. An ex parte application is an application that you bring to the court either because an ex parte means that the court does not have to hear another party, that you do not have to serve on another party, and there sometimes is no respondent in an application that is ex parte. And I say this because if you are bringing an application ex parte in the court, it's because there is no respondent. You want the court to give you an order to either do something or appoint someone to do something. If there is a respondent, and I'll make an example in the High Court because the Magistrates Court doesn't have many examples. In High Court application, in road accident fund claims, many times the person who's represented who was injured in the accident is not capable of managing their own affairs because they suffered a severe head injury or because they are a minor. And because a child is a minor, irrespective of that minor child having parents, that child's rights must still be protected by a curator ad litem. The curator ad litem, in order to be appointed, is an ex parte application, but sometimes the road accident fund is cited as a respondent, but there's no need to serve them with the application. You may serve them with the application, but the application may be heard ex parte. In other words, there's no opposition to the application, or there's no respondent to the application. Have I explained it properly?
Yeah.
You get it, Richard?
Yeah, thanks, Advocate.
Thank you. Whose hand was up next? Was there another question? Right, do we have any other questions? The question was about its application in magistrate's court. Magistrate is magistrate, not magistrate. Example was given about High Court. Itumeleng, do you have a problem with the question? Itumeleng? Okay, so that was an ex parte comment by Itumeleng. Witty R. Ex parte applications are also used when applying for admission as a legal practitioner. Yes, sir, you are correct, or ma'am. Except that admission applications are also done in the High Court, so I don't think Itumeleng will agree with you on that one because it's not match court. Cora, they got it ex parte. Judge Sutton rescinded the judgment last week and gave clear directions with regards to ex parte applications. An interdict can be an example of ex parte for magistrates court. Just coming back to the question of ex parte applications. When Mr. Richard Ali asked the question, I made it clear before answering the question that we are dealing with actions now. And when we deal with applications at the appropriate time, will I elaborate further with regards to ex parte applications if it forms part of the syllabus and their application in the magistrates court. Thank you. Tiro, do you have a question? Okay, Tiro's hand's up, so there is no question there.
Oh, sorry, I forgot to unmute myself.
Okay, that might help.
Yeah, notice of bar. When do you serve notice of bar, the plaintiff?
Where did you see notice of bar? Where did you come across it?
It's just something that I've read or I did at university. Notice.
Okay, sir. Thank you. That's a good question. We are dealing with defendant actions now. After the defendant has failed to file a plea, within the prescribed time period, the plaintiff may serve on the defendant a notice of bar, giving them 5 days within which to file their plea. That is what a notice of bar is. It's also called a notice to plead. You are given 5 days from this notice to file your plea, failing which you shall be ipso facto barred. So that is what a notice of bar is. It's got nothing to do with the place where you buy alcohol and people fall over each other. It is just to bar the person from filing their plea. All right, I hope I've answered you. Thank you. You may lower your hand, Tiro, if you are satisfied. Thank you. Now coming to, we dealt with a combined summons and a particulars of claim that accompany it. You also get, as I said, what is called a simple summons. Now, a simple summons is a summons in which you set out your case. You do not give as much particularity as you do in a combined summons. So you have an option of going the simple route, the simple summons route or the combined summons route. And the reason you go for the simple summons route is for a simple reason. Because the claim is that simple. It's a simple claim. It can be described in a few lines only by the plaintiff. And if the defendant, only if the defendant files a notice of intention to defend that summons, that simple summons, does the defendant require the plaintiff to file a declaration. Now, a declaration is similar to particulars of claim, where the plaintiff is now called upon to elaborate on this claim in the simple summons, because it now turns out that it's not as simple as they thought it was. So now the plaintiff is required to file a more detailed set of facts upon which their cause of action is based. And the defendant, the plaintiff also has a specific time period within which to file that declaration. And if the plaintiff does not file that declaration within that specified period of time, the defendant may apply for default judgment against the plaintiff to dismiss the plaintiff's claim with costs. But before doing so, the defendant must also serve on the plaintiff a notice of bar. And if they fail, to adhere to the notice of bar, then the plaintiff is automatically stopped or barred from filing the declaration. And then the defendant may apply for the plaintiff's claim to be dismissed with costs. Okay, that's the declaration. In my experience, when I practiced in the magistrate's court in my former lifetime, did not come across any simple summons. And as a result, I did not come across any declaration, which tells you that it is not a very well or frequently used pleading, but it is there. It is there for litigants to use. They just don't want to, or they just not sure to do it. And the same applies to a replication. Plaintiff will issue summons and particulars of claim. They'll be served on the defendant. The defendant will then file a notice of intention to defend and a plea, in which they obviously deny things. The plaintiff then has an opportunity to file a replication, in other words, to reply. In application proceedings, the applicant is equivalent to having the right to filing a replying affidavit. But because in actions, I don't know what happens in actions, but plaintiffs just don't replicate. They just don't replicate to defendants' pleas. They just leave it as it is. And yet it's an opportunity for you representing the plaintiff to file a plea, I beg your pardon, a replication to further plead your client's case. Even if you don't raise any new facts, but you can deny what was said in the plea and reiterate what you said, what the plaintiff said in their particulars of claim. So use it more, make use of your pleadings where you have the opportunity to do so. Sasha, thank you for your comment there. Don't jump to subjects not yet addressed by him. He is focusing now on action proceedings, not application proceedings. It is just going to confuse us all. Give that woman a bells. Thank you. Now, coming to further particulars. Yes, sir. There's a hand that's up.
Greeting, advocate.
Good evening.
Is on the note of regarding replication, amended position where as a candidate attorney. This is just my second month as a candidate attorney. I've been given a case whereby they filed summons to the state attorney, and they are seeing that the case has no WhatsApp, but they've given me that case, and like it's about, I think it's like it's a 2020 case, and they've never did a replication, and they've given me that case concerning like to defend for the applicants. So I think that's
applicants, not the defendants.
Yes. So I'm just confirming that what you just said regarding replications, it does happen.
They've not filed replication. Oh, they do file replications.
They haven't, like, but they've given me that case, like, to have a look at it.
Oh, you're just confirming?
Yeah, I'm just confirming regarding replications.
That they don't replicate, eh?
Yeah, they don't, but they've given me that case as a candidate attorney. It's like a 2020 case, so yeah.
Yeah. No, I just watched that case, and they are out of time. If it's a 2020 case, then your plea must have been filed sometime in 2020 as well, or 2021. But it being 2023 now, they are out of time to file a replication. So pleadings have closed now, and you must kick for touch, take it to trial.
Oh, okay, noted. Thanks for that.
But if you don't know what to do, you can always brief me. I charge a very reasonable fee.
No worries. Thank you. Thank you for engagement.
Okay, sir, not a problem. Thank you for your question.
Okay, cool.
Right, now, both parties, the plaintiff and the defendant, we are back on the action now. We are still with the action. Both parties have filed their pleas. Well, I mean, their pleadings. They filed their pleadings. Pleadings have now closed, right? It is time to go to trial. Parties are now preparing to go to trial. The pleadings have been filed. The notices have been filed. Don't worry about the notices, the pretrial notices. I will deal with them extensively soon. They've now filed all their notices and pleadings, and they are ready for trial. But the plaintiff, the defendant, feels that it's not in possession of sufficient facts of the plaintiff's claim. Now, previously, a long time ago, the plaintiff could, or the defendant could, ask for special for further particulars at any point in time. And those particulars may either be, let's say in the case of that example that I made, the petrol attendant, the defendant can ask the plaintiff, how old is the petrol attendant? How long has the petrol attendant been working there? What is his level of education? What is his vision like? Does he wear glasses? Those are questions that they can ask, and that will assist to narrow the issues when they when the matter goes to court. Okay. Rule 2315, Mandy. In respect of 23 is a discovery. Okay. Rule 23 is discovery. So let's see what 2315 says. Oh, are you talking about request for further particulars? That's Rule 16. 23 is discovery. So, yeah, further particulars are Rule 16. Discovery is Rule 23. And so a party could at any time ask for further particulars from another party in an action. However, the rule was changed to provide for a request for further particulars only for purposes of trial. Because there was an abuse of that process in that parties used it as a fishing expedition to test the strength of their client's case, and sometimes to ask for particulars which amount to evidence, which can be obtained during trial. So the courts put a stop to it and said, no, you can only request further particulars for purposes of trial. Not at any other stage and after pleadings have closed, not before pleadings have closed. Because now if you ask for further particulars before the close of pleadings, you can still adjust your plea before you file it, your pleading. So the court said, no, you will file it after the close of pleadings and only for purposes of preparing for trial. Right, now we are looking at the plea itself now. You've heard us talk about pleadings, you've heard us talk about a plea. A plea falls within the category of pleading. Okay? A pleading is the general term used to describe the documents filed in an action that are not notices. Take note, you get two types of documents filed in an action. The one is pleadings, where your client's case is made out. And that'll be your summons, particulars of claim, your plea, your replication, your counterclaim, your plea to the counterclaim. Those all are considered pleadings. Then you get your second category of documents in an action. They are called notices. And they are notice of intention to defend, notice to plead, notice of bar, notice of discovery, notice to attend a pretrial conference, notice of set down. Those are all the notices. Notice of filing of a report. Those are all notices in an action. But a plea is one of the main pleadings in an action. I would almost say it's the second most important document after the summons, because it replies to the summons. And your plea, in your plea, you as the defendant must now answer to the claim of the plaintiff in the particulars of claim. Now,
I'm part of the UK team. Okay, cool. Can I ask that you ask them, because I'm currently in a lecture right now. They'll be able to help you. No stress. You wouldn't have known.
And now they know.
And so do all of us.
Yes, so do all of us. Thank you for sharing that information. So your plea, therefore, will be the document or the pleading that you use to answer to the claim of the plaintiff in the particulars of claim or the summons. When I say particulars of claim, I include the summons. Now, I told you that in your particulars of claim, and all your pleadings, by the way, must be set out in a specific manner as provided by the rules. And that one of those things that you need to do is you need to number each paragraph. Your plea must be divided into paragraphs. The first paragraph is normally the plaintiff's description, address, and all of that. The second paragraph is the defendant's description and address and so on. The third paragraph is normally the jurisdiction of the court. The fourth paragraph is the starting of the facts, to set out the facts in support of your cause of action. And then you have the breach, the delict, you have the damages suffered, and then you have the prayer. Now your plea has to respond to each of those allegations. And the first allegation you will find that you have to answer to now in the plea is that of the plaintiff, the particulars of the plaintiff and the description of the plaintiff. Number one, the plaintiff gives his name as Sean Michael George in the first paragraph. You will then, in response to that paragraph, say in your plea, add paragraph 1 of the particulars of claim. The defendant only admits the names of the plaintiff and puts the plaintiff to proof of the rest of the allegations in this paragraph. So you must either admit or deny, confess or avoid what is contained in the summons or particulars. You go on to paragraph 2. As the defendant drafting a plea, you now have to answer whether you, in paragraph 2, are properly described as the defendant. Are those your correct names? Is that your correct address? Is it correct that you are being sued in your personal capacity and not your representative capacity? You need to address those issues in your plea. You can either say the defendant admits the allegations in this paragraph, full stop. And so you will answer each and every allegation in the particulars of claim. Sometimes when you answer these questions, when you are pleading to in your particulars of claim to the summons or particulars of claim, you may, if you, for instance, want to deny paragraphs 4, 5, 6, and 7, instead of denying each one individually, you'll say add paragraphs 4, 5, 6, and 7. Save for admitting the date on which it is alleged the incident took place, the defendant denies the allegations in all of these paragraphs as if specifically traversed and puts the plaintiff to proof thereof. But very importantly, when you do deny an allegation in a plea, you have to put your version, because now you've disputed facts. What is your version of the facts in contrast to what the plaintiff has said in their particulars of claim? Okay. When does one enter a plea of bare denial? I think it happens when you are viewing on your phone and someone calls you. Okay, is that a bare denial? Okay, a bare denial is when you simply deny without giving a version of facts. It's a relevant question because I am dealing with a plea now. A bare denial is when you simply say the defendant denies the allegations in this affidavit, full stop, and puts the plaintiff to proof thereof, full stop. That is a bare denial because you've not put up a version. And a bare denial, especially in a plea, in a case of delict, means that the defendant has no version before the court, has no defense before the court. And on the day of trial, or even worse, the plaintiff can even apply to court to strike out the defendant's defense in its entirety for being a bare denial and not disclosing a defense. Sandra, you are correct in your explanation to Agnes about a bare denial. Okay. What is a plea in reconvention? Okay. A claim in convention is your summons and particulars of claim. It's referred to as a claim in convention. When the defendant defends that action and files a counterclaim, that claim of the defendant, the counterclaim of the defendant, becomes a claim in reconvention. The plaintiff, when the plaintiff now responds or files a plea to that counterclaim, that plea will be referred to as a plea in reconvention. Correction, it may be referred to as a plea in reconvention. Sipho, I think my explanation will have answered your question. Can someone answer Sipho here? Is bare denial the opposite of bona fide defense? Who wants to answer Sipho? Kwanele says no. Sipho, are you happy with that answer? Okay. Mikateko says no, it is not. Okay, Mikateko has expanded on Kwanele's no. No, it is not. Would anyone like to add on that? Sipho says it's okay. All right, Sipho's okay, we are all okay. Right, let's move along. I want to deal with a replication now. After a defendant has filed a plea to the particulars of claim, the plaintiff needs to plead to some of the allegations in the plea. And the plaintiff will do so by way of a replication. All right, a replication. And as I said earlier, many practitioners do not file a plea, I beg your pardon, a replication. Yes, the plaintiff answers to the defendant's plea with a replication. Sandra, thank you. Many legal practitioners do not file a replication. And I see nothing wrong with, at the beginning of your trial, when the plaintiff, rather after the plaintiff has closed its case and the defendant now needs to lead its case, or even in closing argument, the defendant can say, Your Worship, which is how you address a magistrate in the magistrate's court. I want to point out to the court that the plaintiff has not filed a replication to the defendant's plea in this matter. For that reason, Your Worship, I want the court to accept on the pleadings the version of the defendant as being undisputed by the plaintiff. In addition, Your Worship, I want the court to have regard to the evidence of the witnesses of the defendant, insofar as their evidence was not refuted by the plaintiff. That will give you a strong advantage in your case, your defendant client's case, and it will make the magistrate ask questions which they didn't consider. But also remember that actions, trials are determined on the oral evidence more than the pleadings. And the opposite is correct in terms of your applications. In applications, it is the pleadings that do the talking. In other words, your evidence is contained in your affidavits. That's where you find your pleadings, your evidence, I beg your pardon. So in a replication, you would plead in exactly the same way you would in a plea, either by admitting, denying, confessing, or avoiding any of the allegations made therein. It may not be the be-all and the end-all of your case as a defendant, but it is worthwhile to mention to the court that there's no replication filed here. So your client's version as the defendant must be accepted as stated in the pleadings. And also that the plaintiff did not challenge the defendant's version on the pleadings. Once again, you say there's actually no denial. It's not even a bare denial. There's no denial at all of the defendant's plea. Right, now, not every case goes to trial. Not every action goes to trial. At some point, the parties realize the error of their ways. Obviously, with the assistance of their very capable attorneys, they are shown the bright lights of reason and made to realize that there is actually nothing to fight about. Sometimes the egos of parties gets in the way and they see no reason. It's more so in the case of a divorce, for example, where there is a lot of animosity and anger and emotions involved in the beginning. And the parties refuse to see any reason or listen to any reason whatsoever. There will be huge fights about the car, the kids, the dogs, the fish, the cat, the mother-in-law, the father-in-law on both sides. So there will be massive fights, and sometimes it takes up to a year, if not longer, for that dust to settle between the parties, for them to see reason and start saying, and it usually starts with one party that says, I'm tired of all this fighting. I want this whole thing to go away. Then the parties, when the dust has settled, can sit down, look at each other and say, okay, what do you want? It's called a round table. You negotiate a settlement. Now, in terms of Rule 18 of the Magistrates Court's rules, parties may reach a settlement on an issue, irrespective of what the court says, but the court also has a discretion. Remember, we said they are creatures of statute and don't have a discretion when it comes to the rules. But when it comes to settlement, the court is obliged to exercise a discretion in whether it accepts the settlement between the parties as being a reasonable and acceptable offer. So the court is obliged to look at it in that way. And the parties may informally settle a matter and just put it in an order of court to take to the magistrate to endorse. The parties may also formally settle a matter wherein a formal offer is made, an offer of settlement is made in writing, in terms of Rule 18. The party that receives the offer will look at the offer, consider it, discuss it with the client, tell them whether it's a good settlement or not, and sometimes there will be a counter offer with regards to one, some, maybe all of the aspects of settlement in the original offer of settlement. And once the parties have found each other, figuratively, on the issue of settlement, they will then craft a deed of settlement that encompasses everything that was in there. Or they may put it in, and they may incorporate that draft, that deed of settlement, into a court order by agreement by the parties will go before the magistrate, and the magistrate will make it an order of court and endorse it. The benefit of going to court on a deed of settlement and an agreeing an order, excuse me, is that if one of the parties fails to act in terms of the offer of settlement, the other party can go back to court and say, I want to compel them to act in accordance with this order. They've now breached this order. I want to compel them. Alternatively, the aggrieved party may bring an application against the defaulting party for contempt of court. Any questions? Okay, at this point, I'm going to request that we take a break because I need a comfort break. So how long shall we say? It's 8 minutes to 7 now. In terms of progress, we are doing extremely well. We are actually ahead of schedule. So 1910, okay, Tatejo, 1910 for you. We will come back at 1910 then. Thank you.
In the year 1910.
That too. We'll be going back in time. 10 minutes past 7. Thank you, Richard. Okay, we are back in the year 1910. 10 minutes past 7. Are there any questions that I have not answered? I'm just checking on the chat now. I seem to think there was one or two. I saw something about a divorce earlier on. Okay, Mana, Pamela, you are correct. In divorce matters, most attorneys just assume that the parties will settle. So that could be, you are right, a reason why they don't replicate. I'm just checking something up here on simple summons. Has anyone come across the simple summons in the notes? And if so, can you take us there, please? And if it's not in the notes, you must consider yourselves very privileged, because I took a leap off the beaten track.
It's Rule 5 on page 76.
Rule 5, 76. Can you read for us, please, what it says about simple summons? Simple summons?
Someone who's a much more confident reader, that's not me, sorry.
Okay. Who's more confident? Page 76. Who's daring enough to read for us page 76 on simple summons?
Good.
You may begin.
As stated above, an action may only be instituted by way of summons. Rules 5, 6, and 7, respectively, contain provisions relating to the content of a summons and amendment of a summons prior to service thereof.
Sorry, can I stop you there? Can we go to simple summons lower down?
All right.
In terms of Rule 5 2B.
5.
Where the claim is for a debt or a liquidated demand.
May I go?
Yes, please.
In terms of Rule 5, Sub-Rule 2, Sub-Rule B, where the claim is for a debt or liquidated demand, the summons may be a simple summons similar to Form 2 of Annexure 1. Should I read the examples?
No, it's fine. Thanks for that, Quintus. And the question was from, let me see who asked the question. I think it was Tolagele. Tolagele asked the question, simple summons are issued for liquidated claims only. So there's your answer there, Tolagele. Ultolile, it says, where the claim is for a debt or a liquidated demand, the summons may be a simple summons. Or, and an example, as examples are, where for an account and debatement of it, arrear rentals, cancellation of a lease, eviction in terms of a cancelled lease agreement, cancellation of a contract of sale, eviction based on cancellation of a sale, cancellation. So it's definite things, liquid stuff, liquidated documents. Tolagele, are you happy with the answer?
Yes, I am, Advocate. Thank you so much.
Thank you.
All right.
Okay, Ria Betswe, I hope I pronounced it correctly. Can a proof of payment for a payment made to a third party which is referenced as loan on the document be viewed as a liquidated amount of money? And the questions that hi colleagues, which one of the colleagues would like to answer this question? Only when none of you can answer the question will I become a colleague and answer it. Does anyone like to answer that question? Can a proof of payment for a payment made to a third party which is referenced as loan on the document be viewed as a liquidated amount of money? Okay, this is the part where I transform and become a colleague. Yes.
Because if the amount is specified, then it's or readily ascertainable, then it could be considered a liquidated document.
Thank you for this. I agree with you there. Ria, is satisfied with that answer? If the amount is easily ascertainable or established, and a liquid document, a proof of payment will be considered a liquid document. All right, does anyone else have a question which was not answered? Yesterday, okay, let's first go up here. Scroll up, Kwanele is laughing. Okay, yes, my question was about making a deed of settlement a writ if the party did not pay over. I said yes, only after judgment is obtained, of course. You can't issue a writ on a deed of settlement without judgment. You first apply to the court for judgment in your favor, then you may issue a writ after a judgment. See, Paul, what if the parties to a matter repent and decide to drop it while the matter is already in trial? Is it too late? Let's say, Paul, I don't think they want to repent because they're not going to heaven. I think if the parties reconcile, right? They may reconcile, and I'm guessing your question relates to divorce now. The parties may reconcile during the process. I've had a divorce case where after the, and I happen to know both parties, the husband and the wife. I acted on behalf of the husband. I beg your pardon, the wife. And we issued summons against the husband for divorce, after which he contacted me. I called both parties into a round table. We had a discussion about it, and the parties realized that they don't want to get divorced. We withdrew the divorce summons. They then reconciled, and it's never too late. Hey, look at Lazarus. He woke up 4 days after he had died, so it's never too late. Right, Sikumbuzo, given Nzuza, yesterday we're supposed to be shown a letter of demand or a certain document displayed. Do you owe me money, Sikumbuzo? I will gladly send you a letter of demand. Okay, let's look. Has anyone come across our notes, has come across a letter, an example of a letter of demand?
Someone said it's on page 206.
206. Okay, shall we go there? Let's go see what's happening at 206. Right, 206. Sikumbuzo, are you there? Page 206. Do you see that example of a letter of demand there? There's one. Is it the one in terms of the National Credit Act? I think it is that. There's an example of a letter of demand. There's one in terms of section 19 of the Alienation of Land Act as well.
And one in terms of a motor vehicle accident, just above the section 129.
Yes, damages by registered post. All right, can I also add that in terms of letters of demand, when you are writing a letter of demand, you have an idea as to who the person is whom you are writing this letter of demand to. You have an idea of their level of intellect. So you have to pitch your letter at that level. If you are writing for a professor of English, you will not write the same way you would to a laborer. And this is in no way discriminating against any professions. You must, as a writer, know who your audience is going to be and pitch your letter at the relevant level. Also, we are encouraged to use simple language that we use on an everyday basis for the people who are going to read these letters of demand to understand exactly in ordinary terms what is being said. And I've seen this over the years that I've practiced. We act in this matter on behalf of Joan James, whom we will refer to as our client hereafter. Our instructions are to demand from you, as we hereby do, payment of the amount of 200,000 rands within 10 days of this letter, failing which we will institute legal proceedings against you, and you will be held liable for costs on an attorney-client scale. Full stop. That was long-winded. I had to take a breather after saying all of that. Write in shorter sentences. And here's an example. We act on behalf of Joan James. Full stop. They already know that she's your client just because you said that. Our instructions are, or rather, we are instructed to demand from you payment of 200,000 rands. Full stop. If you do not pay this 200,000 rand within 10 days, we will sue you. Full stop. Short, sweet, simple, to the point. There's no ambiguity there. It can only be understood in one way and one way only. When that person gets that letter, besides being shocked at the content thereof, they will understand easily what is being wanted. Okay, so these lawyers represent Joan James, right? I know who Joan is, and I know that I owe her money. Oh, there it is, the 200,000. They say that they demand the 200,000 rand which I owe her, and if I don't pay it within 10 days, they will sue me. They will sue me. Simple, straightforward, and to the point. So I hope we all now know what a letter of demand looks like. It is in the book as you've seen it, but I've just given you an example of how to simplify it and make it more effective. All right. Okay, all right, Kwanele, got that. See page 206 in the training guide for an example of a letter of demand. There are also examples of particulars of claim at the back, where you have found your examples of your letter of demand. After that, basically everything that we've referred to is in here. There's even an offer of settlement, an offer to settle, a notice of intention to defend. They are all contained in there. Some jokes in there, love this class. Okay, how do we know that their payment is legitimate? Whose payment, Cora? Are you referring to that third-party payment there?
But I was referring to your question where you asked whether a proof of payment can be regarded as
As a liquid document or liquid amount.
I can't remember now what you said. Sorry, I'm driving. Yeah.
No, that's fine. I assumed correctly that that's what you were referring to. Of course, there are ways of verifying the payment. You can even get the person who received the payment to depose to an affidavit confirming that they received the payment and that the payment was in respect of the case in issue and not any other issue. And also, if it is in dispute, remember you are issuing summons here, so we are going the action route, and there will be a need or a time when that person will be called to testify on that evidence. Sasha wants to know, let me see, first Quintus said something. Wouldn't it be up to the parties to prove or disprove depending on who averred? That is, the party who alleges must prove. That's correct, Quintus. The principle always applies. He or she who alleges must prove. So you cannot just make a bold allegation about something. You must prove what you are saying is true and correct. Sasha says, what if someone agrees in writing on a piece of paper that I borrowed, for example, 50,000 Rand from you? Is this seen as a liquid document or liquidated amount? Yes, you can write it on a piece of toilet paper or a tissue, as long as it's an agreement by parties. There's a case in which a deceased person had written his will on a piece of tissue, a napkin, what you call a serviette in a restaurant, and it was disputed, but the court found that that is the true intention of the testator. So it's not the piece of paper that you write it on. It's the content. It's the content of what is contained in there and the intentions of the parties. The intentions of the parties are always looked at where it's ascertainable. But if not, then the rules of interpretation will be applied. How about using ChatGPT? Oh, I'm old school. Hey, now you've lost me. I've heard of ChatGPT. I've seen it somewhere. Can someone help us there?
There was a recent article that I read where lawyers had drafted documents using ChatGPT, and it turned out that the drafting that they had, there were errors inside of as to what the law states. So it gave a misrepresentation of the law, and the courts kind of rejected those papers because the finding ChatGPT isn't always 100% correct. It might draft well, but then you also still need to fact check and make sure that you're not just copying and pasting the document that you get from ChatGPT.
Okay, thanks for that explanation, Quintus. I think I am nowhere closer to knowing what ChatGPT is about, but I will read up on it.
So I can add a little bit on that. So a ChatGPT is like a drunk uncle who knows all the stories in the village, but does not know where they had them. So to try and use them
Rumors.
as yeah, so there's something that they call hallucination when it comes to artificial intelligence, which happens when you keep asking questions on artificial intelligence and they are trained to give you answers. So you ask questions on things that have not been trained on responding on, they will still give you the answer because their main priority is to give you an answer. So they will prioritize and compromise, they will compromise facts and reality in order to prioritize giving you an answer. So we see this quite a lot in the professional space where people are using ChatGPT, but then the data cannot be cannot be fact checked, you know, because what they do is they feed that model with lots of data that is existing, but it does not have a database where it can go into the database and say, oh, this question that you're asking, the file that gives you the answer is sitting in this particular point. It's just knowledge that they know, and they don't even know where they got it. Exactly.
Thanks, Kwamile, for that explanation. Quintus, are you able to provide us with details of that particular case, please?
So it was an article. I see someone has posted it, but this looks like a US article. Nintendo has posted it.
Yeah, it is US
in the group. So ChatGPT is basically artificial intelligence. So it's a machine program that just gathers everything from the internet and then spews it out in a well-formulated version. So you can get various. So you can take one set of facts and put it in, and then. But the problem is that it doesn't take into consideration factors such as jurisdiction and the applicable legislation of that country. And if it doesn't have information, it uses what you've given it to build further information when someone else does ask the question in the future.
So was it that case that was put on there, that American case?
I need to go and find mine. I just read it on my morning news. I'll find mine and see, just verify that it is the same one.
Is there an example, a South African example? You must remember, whatever happens in America and abroad takes another 20 years to get to us.
No, it happened in America, and I think recently it also happened in South Africa.
Also South Africa. Okay, no, it'll be interesting to know, though, because we need to get up to date with these things too, because if it's happened in America or elsewhere in another jurisdiction, it's bound to find its way into our jurisprudence soon. But remember also that we are lawyers and we are here to develop our jurisprudence. We don't have to follow judicial precedent all the time, especially if there isn't any. Especially if there isn't any precedent. We will need to look at jurisdictions abroad, and we must challenge ourselves to want to develop the jurisprudence in our country. Our law is dynamic, and because our constitution is so young, from 1996, of course, we know that we still have lots of room to develop our law. So yes, by all means, challenge it if you have to. If you have the means, look at foreign jurisdictions to develop our law.
Shalika's posted it in the chats, the article.
Okay, thanks so much. Where the session's long being recorded. Okay. Okay. Given that magistrates' courts are creatures of statute and do not therefore possess inherent jurisdiction, do they have the necessary jurisdiction ground further and alternatively beyond what is specifically prayed? Okay, Aiden wants to know, given that magistrates' courts are creatures of statutes and do not therefore possess inherent jurisdiction, do they have the necessary jurisdiction to grant further and or alternative relief beyond what is specifically prayed? Technically speaking, Aiden, no, they don't. But from a practical point of view, no, it stops right there. They don't have a discretion either to award alternative or further relief to a party. If a party hasn't asked for it, they're not entitled to it, and you must argue that the law says you are a creature of statute and you must follow the statute to the letter. Okay, lawyer uses ChatGPT in federal court and Matt Novak, not that one, it's the other one. Is it the one by Julik?
That's the one, yes.
Dolly Zukiswa Kalai, I hope you are aware. Go check, she's recording the class. Okay, she is. Okay, I'm gonna read up on this, right? Off this platform, not now. And then Martin Lovo also posted something. Magistrate rebukes lawyers over ChatGPT bogus cases. Interesting. It gets interesting. Okay, Leslie Sampson is asking, are we able to download the recordings on the Teams app? Okay, I don't know. You'll find out. Zukiswa will be able to answer you there. Using fake references judgment generated by ChatGPT. A language model, an AI language model. Declared that the names, citations, facts, and decisions presented by lawyers were initially fictitious. I saw one on LinkedIn that happened in SA. We'll try find it now. That's Gareth. ChatGPT, Cora says, offered me Jones versus Buckle as authority. As authority? Jones versus Buckle or Jones and Buckle? Because Jones and Buckle is a publication on Magistrates Court's practice. And Julique once again gave us the court in the regional court. Okay. Sasha.
Advocate,
Yes.
can I interject? My name is Sam.
Yes, Sam.
Yes, the same topic we're talking about ChatGPT.
Yes.
Actually made headlines news on Sunday Times last weekend, this Sunday Times, the past Sunday. It's actually on the paper, but it's not said which lawyers are those who actually gather their facts based on ChatGPT. But the court actually rejected that kind of evidence.
Okay. Thank you, Sam, for that.
But would that not constitute professional misconduct, though? Because, I mean, as lawyers, we're supposed to be able to read the law and be able to then interpret it and apply it, or, you know, argue the law professionally. Say, if I'm just putting something into a program that's going to spit something out and I'm just going to submit it to the court, it shows that I'm not doing my due diligence as an officer of the court.
And your competence may be called into question, because at university, you were taught that these are the sources of law. ChatGPT is not one of them. It's not a reliable one. And that is why you were never told in research methodology that Wikipedia is a reliable source of authority. In law, it is not. It is to be rejected with the content that it deserves. So ChatGPT, in order for it to become a reputable authority, still needs to be developed, still needs to be tested and accepted. So far from what I've heard and from what I've briefly scanned now that has been posted up here, it's not reliable, and it's not, you can't test it. Yes, Richard.
Yeah, thanks, Donovan. Yeah, as lawyers and candidate attorneys, there's always two things that comes to mind, and listening to the GP chat, I'm still very old school, is there's two questions or one question that you should ask in law: admissibility and relevance. And is GP chat, whatever they call it, admissible, and can it be used in court, and is it relevant? Thanks, Tony. I just wanted to make that comment.
Okay, thanks, Richard. All right, let's close the deal on ChatGPT. We all have homework to do, some of us with more than others. I now want to move on to something called exceptions. You've heard the phrase, I take exception to what you are saying. Now, the same applies. Mahlatse says the system keeps on kicking him out. Is there something that I'm doing wrong? I don't know, Mahlatse. How is it kicking you out? Do you have load shedding, or do you have electricity where you are? It could be an issue, or maybe your broadband, your bandwidth may be a challenge. Janus?
Yes, Counsel. Apologies, my computer's a bit slow. I think I'm preempting with this question, but just somewhere in your discussion, can you perhaps discuss the difference between exception and vague and embarrassing, please?
Yeah, it forms part of it. It forms part of the exception discussion we're going to have now.
Thank you. Thank you, Counsel.
Thank you for your question. Right. Now, In terms of Rule 19 of the Magistrates Court's rules, a party may accept to a pleading filed by another party on two bases. The first basis is that something in the pleading is vague and embarrassing. And when something is vague and embarrassing, the party objecting or raising the complaint must give the other party notice in writing, informing them of the complaint that is making the pleading excipiable. The party that receives that notice has 10 days to either remove the complaint by amending their pleadings or leaving it as it is if they believe there's nothing wrong. So after the 10-day period has expired and the other party has refused or failed to amend that pleading in terms of the complaint, the party that sent the notice has a period of 15 days within which to set the matter down for hearing in court, for the court to decide whether it is vague and embarrassing. And the relief that the party will seek is that that portion of the pleading be struck out because it's vague and embarrassing and they've refused to remove it. Janus, are you still with me? Am I still making sense?
Absolutely, counsel. But now that you mentioned striking out, I'd also believe that there's an application to strike out certain parts of a plea as well. I'm not sure if that forms part of exception. It's
a separate application. It's a separate application that you bring to strike out any offending parts in a pleading. You can apply to strike out the defense of a party that files a bare denial plea.
Understood. Thank you, counsel.
Thanks. Now, what is vague and embarrassing? You ask yourself, what is vague and embarrassing? I'll make an example of something that happened to me, a case that I was involved in. The plaintiff issued a summons, which was served on my client, the defendant, and in there, they used English words in the incorrect context. One of them was that the plaintiff was binded by the defendant's officers. Well, that doesn't make sense in English. They probably wanted to say they were bound, but it's vague. And you are going to be, and it's embarrassing for you to reply to something like that with specific particularity because you don't know what the plaintiff is trying to say. Even if you do, but how are you going to guess what they are trying to say? So it is vague and it's embarrassing. It's going to embarrass you to have to answer to something which you don't understand. I hope I've explained that to you, Quintus. It's rather
thank you.
Yeah,
I didn't understand that it was a reciprocal duty because what you did was vague, which would mean that me responding would be embarrassing. Thank you.
Yes, thank you. So now coming back to the exception again. The exception, you may raise an exception to a pleading also where the pleading does not disclose a cause of action or a defense in the case of a plea. Richard? You are unmuted.
Sorry, counsel.
So you, in that case where the facts in the pleading do not disclose a cause of action or do not disclose a defense, you do not have to give the other party notice to remove that complaint. You simply set it down for an exception and to strike out that that impugned plea or particulars of claim. So they don't even have a chance to amend. You straight away set it down for argument, and you undergo an order that it be struck out. And it could even be the entire claim of the plaintiff or the entire defense of the defendant. So you just need to look at the facts as they are presented and pleaded in the pleading. Right, now I hope everyone understands exceptions. We've dealt with counterclaims, Rule 20. Rule 21. We've dealt with a replication and a plea in reconvention as well. I want to talk about litis contestatio. Litis contestatio. It's a Latin word which refers to the close of pleadings. And when are pleadings closed? What does it mean when pleadings are closed? It means that the end is near. The parties have now pleaded their cases. They can now start getting ready for trial. How do you know when pleadings have closed? According to Rule 21, capital A, pleadings shall be considered closed in the following circumstances. 1, if either of the parties has joined issue without alleging any new matter and without adding any further pleading. In other words, summons is there, a plea is there, no replication has been filed, no replication is going to be filed, and an inordinate period of time, let's say 3 months, has lapsed without any further pleadings being filed. Those pleadings are considered closed. A second instance is where if the last day on which a replication or a subsequent pleading was to have been filed and it has not been filed, then pleadings are considered closed. Another instance in which pleadings may be considered closed is if the parties agree between themselves in writing that the pleadings are closed, and such agreement must be filed with the clerk of the court or the registrar if it's in the regional court. And lastly, if the parties cannot agree between themselves that pleadings have closed and when they have closed, then the court must declare pleadings closed, but the court does so when one party applies to the court for the court to make such a finding that the pleadings have closed. And that's the case where parties are not able to agree that they've closed. The one says they've closed, the other one says, no, they've not. Give it to me in writing. No, I won't. I'm not agreeing with you. You do what you want to do. Okay, fine, I'm going to court. Notice of motion with a founding affidavit. The notice of motion will say the applicant will seek an order that or rather let's stick to the plaintiff and defendant. The plaintiff will seek a court order that the pleadings have closed because we cannot agree. The defendant does not want to agree, even though no further pleadings have been filed and the time for doing so has lapsed. The court must now declare the pleadings closed. That will happen. Okay, security for costs. What is security for costs? If a party enters into litigation, that party immediately becomes liable for costs. There's a possibility that costs may be awarded against that party. And if that party is not able to pay those costs because they don't have any realizable assets, they don't have any attachable property, the opposite party will suffer financial loss. So therefore, that party may require the other party to file a security for costs. And how is security for costs filed in the magistrate's court? Anyone? Janus, have you come across it yet?
Apologies, counsel, you cut out there at the last moment. I didn't hear the question there.
I'm asking, have you ever had to file security for costs for a party?
Oh, yes, but it was the most ridiculous request ever.
What was it?
Well, they requested that we pay, when was it? Oh, yeah, it was 250,000 for security for costs. And it was a magistrate's court matter and the claim value was 50,000.
Jeez, that's absurd. What was your response?
Well, I referred them to the magistrate's court rules, and I told them 250,000 as for cost of security for a 50,000 rand basically liquidated claim. I asked them firstly whether it was a typo, and they said they reiterate their standing of the first instance. So I asked them, please explain to me how one can file 250,000 security for a claim that's a portion thereof. And I haven't heard back from them since. And apparently they've abandoned the claim as well now. So
yeah. So a party can therefore ask for costs. But in such a case, what you should have done was you should have filed a notice of objection to that security for costs. And in your notice of objection, you should have also said you call upon the clerk of the court to set an amount for security for costs. The clerk of the court or the registrar of the regional court are both empowered to set an amount for security for costs, a reasonable amount. They've been specially trained to do that. And in your notice of objection, you even make a suggestion that you think, in your view, an amount of 5,000 rand is a reasonable security for costs. Or even 1,000, yeah.
At the bottom of page 109, it says that the last point, the court never involves itself in determining how much security should be furnished. Does that not run contrary to what you say?
Let me just have a look. The court never involves itself in determining how much security should be furnished. Have a look at the sentence, the paragraph preceding that. The registrar or clerk of the court may, upon written request of the party in whose favor security is to be provided, and on notice to interested parties, increase the amount thereof if he or she is satisfied that the amount originally furnished is no longer sufficient. So they also, the clerk of the court also, have a look at the one before that. Any security for costs, unless the court otherwise directs or the parties otherwise agree, be given in the form, amount, and manner directed by the registrar or clerk of the court. Did you see that part?
I saw that now. Thank you.
Okay, thanks. Yeah, and that last one contradicts, but you remember, but must also take note, Quintus, the clerk of the court or the registrar of the court and the court are two different things. The court refers to the magistrate. All right, so security for costs, unless there's a specific application brought for the filing of security of costs that is opposed and it's going to go to the court, then the court will be involved. I don't agree with that statement that the court also never involves itself in determining how much security should be furnished. That should say that the court will only involve itself in determining how much security should be furnished and if security should be furnished upon application by one of the parties on notice to the other party. All right. I think that,
Advocate,
yes.
I think I'm in agreement with your view. So when I read through this and I understood the preceding paragraphs too, then the last sentence for me meant the court will never, if there is no application from the parties, involve itself, nor is it obligated.
Thank you.
But
That's,
when you read it alone, then it sounds contradictory. But when you read the preceding paragraphs, my understanding was then this it refers to the magistrate and not the officials in the court. The magistrate would only look into it when there's an application brought forth, but failure which the court will not involve itself.
thank you for that.
Thank you.
Tokoloho. Phew. Okay. Out of curiosity, can you amend pleadings after close of pleadings? Yes, you can. You can amend pleadings in an action in the magistrate's court, as well as the High Court, right up to just before the magistrate delivers his or her judgment. So you're not limited as to when you can amend. You can amend any time, right up to before, even after the trial has been heard. The trial has been heard, evidence has been laid, closing argument has been done. The magistrate says, I reserve my judgment, and sits on that judgment for, I'm waiting for a judgment in one of the magistrates' courts, regional courts now, for 2 years. I don't have a judgment for 2 years. I can still go and amend my pleadings even now because there's no judgment. I can even amend my pleadings now. So, Toko, you can amend your pleadings at any time after the close of pleadings, but before the judgment is delivered. What if Kwanele wants to know, what if the attorney and his or her client are incapacitated the same day and fail to file any further pleadings due to that incapacity, and the court and the opposing party are none the wiser and the pleadings consequently close? Can they be reopened, and what is the procedure to that effect? Okay. Your scenario, because both parties are incapacitated, what happens in the legal field generally? Attorneys grant each other indulgences. And the first thing to do is pick up the phone. And I'd like to believe that we are very collegial in this profession. You pick up the phone and you say to your colleague, listen, man, we were supposed to file a further pleading, but both my client and I were incapacitated because we had a party the night before, or because we were in a car accident, or blah, blah, blah. Can you please give us an indulgence until Friday, because we want to file this pleading? They will most likely say, let me take instructions from my client, but send it to me in your request to me in writing so long. And when they do receive your request in writing, they will have consulted with their client and explained if they are ethical attorneys. They will have said to their client, if we don't give them the indulgence, they will most probably go to court, and the court will give them an indulgence. Not may, the court will give them an indulgence, but we may just be in the firing line in that we are now liable for costs of an application of them having to ask the court. And they may even ask for punitive costs of attorney and client scale, because our consent was unreasonably withheld. So you remember, you always have a duty to guide your clients in the right direction. Okay. Depending on the stage proceedings are at, a party who wishes to amend their pleadings may have to seek leave of the court to do so. Thank you, Sandra. That is only in the case where another party objects to your notice of intention to amend, because before you file an amended or amend any pleading, you must first give your opponents written notice of your intention to amend. And in your written notice, you will also give them 10 days within which to object to your amendment, if they so wish. And if they don't object, your pleading will be amended. Where they do object, you will then bring an application for that amendment. And you'll say in your application that the objection is without merit. And as a result, you must be given permission to amend your pleading. Okay? Why should an INCOLA tender an amount for security? What is an INCOLA? Who can tell me what an INCOLA is?
From my vague memory of criminal procedure at varsity, an INCOLA, wouldn't that be someone who resides within the jurisdiction of the Republic? Whereas a peregrinus is someone that's not within the Republic.
Jurisdiction of the court, and then the foreign peregrinus would be a person who's a foreigner not residing in the jurisdiction of any South African court. Then a peregrinus would be a local peregrinus would be, or pellegrini would be people that are not
okay, before we go to peregrinus and peregrini, let's do INCOLA, because it's after 8 already, and I think we've lost a lot of people's concentration by now. An INCOLA, who can tell us what Auntie Google says? What is an INCOLA?
Advocate.
Yes.
From a vague memory when we were still at university, I think the INCOLA is someone who stays or who resides within the court's area of jurisdiction.
But is a foreigner with limited civil rights. Isn't it? But is a foreigner with limited rights, civil rights. It's a person who does not have Charlie Maluleke, can you please mute your microphone? Thank you.
Sorry.
Thank you. An INCOLA is a person within the Republic of South Africa who is from a foreign country but does not have full rights, civil rights. And those civil rights mean, I'll make an example of someone from, sorry about this, Zimbabwe, who does not have a valid passport, but is in the country. You can almost say that person is in the country illegally. And where, for whatever reason, you become involved with that person, and as a result, you believe that you need to sue this person, and this person decides to defend your action against them, your legal action, you have every right. That the fact that they are an INCOLA means that they don't have a set residential address. They have no attachment to the country whatsoever, and that infers the constitution, the jurisdiction of the court. And as a result, that is your cause of action for demanding security for costs. Because should you lose the case against them, you don't know if you are going to be able to recover your costs. You don't know if they are even going to be in the country at the time. Okay, 2 years. How is that anywhere remotely related to a speedy trial? Was that question for me, Janus? Where's the 2-year question?
Actually, yes, it was, Counsel. When you said you've had a judgment reserved for 2 years now, I'm shocked. I'm honestly shocked.
Listen, I've got another case in the Labour Court. That's also going for 2 years. In October, it'll be 2 years. The magistrate, the regional court one is actually over 2 years. It was heard on the 5th of May, on the 10th of May in 2021. The Labour Court one was heard in October of 2021. We still don't have a judgment.
Counsel, what's your recourse in a case like that? You can't exactly bring an application to compel a judge now, can you?
No, you write to the judge president. Your attorney will write to the judge president and tell the judge president that because in terms of the norms and standards of judges, they must deliver judgments within 3 months. And anything beyond that, they must give an explanation. So you must write to the judge president. If you don't, then you accept that you have to wait. It's really justice delayed and justice denied, but
I think if we look at the Senzo case where the judge, Mahumela, who was suspended for many of their judgments, of his judgments being not according to the prescribed time, that is justice denied, because now the entire trial has to start from scratch, which I think everyone who's a soccer fan has been watching that with red sore eyes, trying to get this thing. Yeah.
Thank you for that. Okay, what are the main reasons behind prolonged reserved judgment? Is this a good practice? Start with your last question, Matome. No, it is not a good practice. The main reasons are that the presiding officer is not committed to their job. They do not care about the rights of litigants, and they simply, or sometimes, like I suspect in my regional court case, the magistrate doesn't know whose favor to find in. It's just a difficult case for the magistrate to decide. All right, please mute mics. Okay, mics have been muted. Quentin says, I once watched a Judges Matters interview, and the interviewer said justice delayed is not necessarily justice denied. And likewise, justice delivered speedily is not justice served. On the other hand, there have been arguments raised that there are judges and magistrates who have long-standing judgment. Yet again, we are taught that we should not interfere with the processes of the court. But as a litigant, you have every right to complain to the powers that be that, hey, I've been waiting. Hello, my judgment here. I need to move on. When a court reserves the judgment, it means the matter has been kept in abeyance for a while. This is done after all the parties have completed their arguments and all the written submissions have been filed in the court. Sandra Janiak. Okay, when a court says judgment is reserved, or when a court says the court will take time, it means that the court needs the judge or the magistrate. Let's confine it to magistrates because we're doing magistrates courts practice here. It means the magistrate has heard all the arguments, needs to now go and consider the evidence, needs to now go and research the law and put the two together to come up with a sensible judgment on the matter. As opposed to, right after a matter has been heard, the magistrate says, I'm now going to give my extempore judgment. Extempore means off the cuff, right there immediately. The judge then gives a short version of a judgment and says, I now deliver my judgment. Should any party wish to apply or wish for me to provide them with full reasons for my judgment, they must do so within 10 days of today. And the parties go away. That is how justice can be dispensed with speedily, but not all magistrates and not all judges are able to do that. They would much rather take their time to consider the facts, the evidence, and the law in order to come up with a sensible, well-considered judgment. But it's an overwhelming job, because the moment you finish with that case, you go back to your chambers, you have a cup of coffee, and while you are still thinking about this case, another file gets plonked on your desk. There's another case for you, by the way. So the case you've just heard now, instead of starting on the judgment, you move it to the edge of your desk because you've now got another burning fire in front of you. And the same is going to happen every day, because the moment you finish a case and you move it and you have your cup of coffee, another one lands on your desk, and you have to just consider that without realizing there are 20 files now in your chambers, queuing, lining up, all for judgments. Meanwhile, you've forgotten the evidence in the very first and all the other 19 cases before that. It's difficult for you. So you actually need time to get back to that, to get to the cases themselves and listen to the evidence on tape so that you can get back to it. It's an unfortunate reality. Okay. Yes, Malikole, you must go claim your fees from the university for the INCOLA issue. And you can actually go simple summons. There's no need for combined summons. You can do a simple summons, and only when they defend your action can you do a declaration. So Tolagele wants to know, so what will you tell your client? In which case, Tolagele? So what will you tell your client? Just to be sure of the context before I answer. Tolagele is gone. Tolagale. Okay. Malikole, my limited understanding of an INCOLA is that an INCOLA is a person, juristic or otherwise, residing or conducting business within jurisdiction of the court, particular high court from which seeks to file their matter. But again, that's just off top of my head and it's theory. Is it Malikole who, oh yeah, you've got a cause of action against your institution for your fees. At what point does the court review all long pending and outstanding matters where judgment is reserved? Someone said that you have the right to also refer a complaint to the JSC, which is the Judicial Service Commission, which is correct. The Judicial Service Commission is the oversight body of judges, where claims can be lodged, complaints can be lodged against judges. And I think a delayed judgment of 2 years is enough grounds to lay a complaint against a specific judge. But the lines of reporting, in terms of the lines of reporting, you have to report that person to their supervisor, which will be the judge president of that division. Okay. At what point does the court review all long pending and outstanding matters where judgment is reserved? On a quarterly basis, the judge president has meetings with these judges where they have to give reports as to which judgments are outstanding. Actually, on a monthly basis, they have to do that. As to what happens at those meetings and why they are not called to order with regards to reserved judgments, I don't know. Nimisha says, delayed case. Tolagele, reservation of judgment. Cora, can one issue a provisional sentence summons in respect of a taxed bill of costs? Right, now let's look at provisional sentence summons. What is a provisional sentence summons? And my answer to you, my quick answer is yes, you can issue a provisional sentence summons in respect of a taxed bill of cost, because you have the taxing master's stamp and signature on the allocator, which awards you costs in your favor. So that is a liquid document. Provisional sentence summons is where you can use a liquid document in respect of a liquid document where you can, after having issued summons and the matter is not defended, you can apply to the court for provisional sentence. Provisional sentence is the same as default judgment, but you can obtain it much more in specific cases only, and this would be such a case in which you can do that. Provisional sentence. That's the third type of summons, by the way. And you would also use provisional sentence summons where you have something, a negotiable instrument like a check, a promissory note. That's where you can use the provisional sentence summons procedure. But again, provisional sentence summons is another rare breed. You hardly come across it. I am yet to see one in my short term as a legal practitioner. And I only started in 1999 as an attorney. So I'm yet to see one. Maybe I still will see one. I'm just trying to check here. All right. Okay. Dobeko. The mics unmute themselves. Yeah, sometimes they do. I'm asking this just so I know and constantly check. Is it maybe a settings issue? Good. At least I'm sitting on your shoulder there, Nontobeko, about the unmuting and the muting. But don't worry, I'm fine with it now. I won't make much of a fuss. We're the third day already. I understand if it's by accident. And the reason why, I just don't want you, I just don't want your colleagues here, your classmates, to hear embarrassing things about you because your mic is unmuted. So it's for your own protection. Right. Now, I want you to look at, and Sasha, I remember a question you asked on the first day about questions after each session. I want you to look at, do you have what is called the civil procedure program for this session that we are doing here?
Yes, we do, Advocate. We
You do have it.
Yes, we do, Advocate.
Okay, when you look at day 4, or rather, let's look at, and this is also going to help you to prepare for the board exams. I know some of you are writing board exams now. If you look at the end of each session, there's something called learning objectives, where it says draft a notice of intention to defend and indicate how and when it will be delivered, or it must be delivered. Indicate when and in respect of which instances summary judgment can be applied for. But before that, you go up to the 12th of July, which is today's date, and you look at rules 5 and 6, and you draft the particulars of claim in the following causes of action, which are based in each instance on a given set of facts. Make up your own facts. Sure, you can be creative by now. A motor vehicle collision, breach of contract, non-payment of rent, misrepresentation, estate agent's commission, a dishonored check. And there's an example of provisional sentence summons, an acknowledgement of debt, and amended particulars of claim in terms of Rule 55, capital A. So you've got the program. It's got the outline of what we are supposed to be doing. And give yourselves the exercises. Do the exercises and try and answer those questions. They will be relevant for purposes of the board exams. Okay.
Perfect. Thank you, Advocate.
Pleasure. Humphrey. taking me back. Okay, what happens after you issued summons and a defendant wants to make a payment arrangement? You listen to them first, Humphrey, and it's called an acknowledgement of debt or an admission of liability. You can make that agreement an order of court. That is what we refer to as the deed of settlement, right? It's a deed of settlement or an offer of settlement. And once it's accepted by the parties, you can make it an order of court, signed by both parties. And then you go to court and you say, Magistrate, Your Worship, we would like to make this an order of court. And they will endorse it if they are happy with the contents thereof. When there's a long list of unknown users, guest people don't want to show their names. Okay. Now, I want to address that issue. Thanks, Nimisha, for mentioning that. Now, we know that, unfortunately, some of us have shared the links to these classes with our friends or whoever. But remember, you have paid, you have registered for this course. It simply means that someone who has not registered for this course is now benefiting because of you. Is it fair on your colleagues? Is it ethical behavior? So please don't share the link with your colleagues or your friends. It also puts a burden on the platform, and that's why you have interruption of sound when that happens. So please, I'm asking you, I'm begging you not to share the link. All right? Thank you if you've stopped doing that. Right. Okay. We are left with 8 minutes. We were going to go until 9 o'clock, but there's not going to be a need for that because we are, as I said, well ahead of our time. And because we are going to be ahead of our time, I'm going to be able to do more with you. You will see from your program that after day 5, we are only scheduled for day 5. Elodie, no, the lecture is not on break. I'm still here very much. After day 5, it says self-study in red. But if by tomorrow we are able to make good progress, because like good students, we are going to ask relevant questions so that I can get to do a bit more with you guys on Friday. And this is the part where you realize that I'm actually nice and I want to help you, to explain to you as much as possible that is contained here. And as you can see, from day 6, there's a day 6, there's a day 7, there's even a day 8. 3 extra days in addition to what I'm supposed to do for you up to Friday. But if we can limit ourselves to relevant questions tomorrow, we can actually avail more time to ourselves for me to go through the rest of the stuff with you. All right. So on that note, let me then take this opportunity to thank you. Yes, Sasha?
Sorry, Advocate. No, I actually just before you want to thank us, I actually want to thank you. Thank you so much for your indulgence and for paying attention to all our questions and for answering all our questions so, insightfully, and we really learned a lot. I think all of us are very, very happy with the way that you have been providing us with your knowledge and your classes, etc. So I actually just wanted to thank you before you thank us.
Thank you, Sasha, for your kind words. I actually do have your interests at heart, and I only want the best for you. But in order for you to get the best out of yourself and for yourself, you must be receptive. You must want to learn. And I can promise you, the sky is not the limit. The limit will be the sky if you only want to reach higher. Okay. Thank you for your strict approach. Okay. It's strict out there in the real world. That's the only reason why I'm strict with you guys, because I want the best for you. Okay. Alrighty, class, with 4 minutes to go. Any other questions before we go?
Advocate, hi, evening. It's Nimisha.
Evening,
I
Nimisha.
think it was a question someone posted, but I think we got the other question. I think just last thing was in terms of reservation of the judgments, and particularly where you mentioned it takes 2 years. I think this is more probably the humane side. How does one handle a client in terms of the delay that's and whatever other I don't know what is the consequence of that, and how does one handle a client? So it's not really a sort of question, but just to understand how would one do that.
Thank you, Nimisha. That's a very important question and a very good one, because you must remember that that judgment has to do with your client's case. Your client's rights are affected by that, and your client wants to move on with their life, and that judgment is standing in the way of their life. And you as the attorney, your client will bug you. Your client will bug you regularly for that judgment, and you keep on saying, no, the judgment's not out yet. Your client will ask you the difficult questions. What are you doing to get the judgment? Because if the magistrate is not delivering the judgment, have you reported them to their superior, to their supervisor? Who do the magistrates report to? There's a magistrates commission, by the way. Similar to the Judicial Services Commission, there's a magistrates commission to which you can report magistrates. But if a magistrate doesn't deliver a judgment, you report that magistrate. You write a letter to the clerk of that court, of the registrar, the clerk of the district court, or the registrar of the regional court, asking them for the judgment. And if they don't respond, next in another month's time, you write to the chief magistrate to whom that magistrate reports. And if there's no joy from there too, you escalate it to the magistrates commission. And the magistrates commission, in fact, the judge president of the division 2 of the High Court, the magistrates also fall under that judge president. So you may escalate it to the judge president and also to the magistrates commission. But your client will nag you, and that will put pressure on you to do something. So thanks for that question, Nimisha. It's a very relevant question.
Thank you very much.
Thank you. One last question or comment or concern before we say good night.
I have a question, Advocate.
Yes, you may ask.
Thank you very much. So with regards to default default judgments, and you have a contract that you are relying on, well, the cause of action stems from that contract that you entered into, but then you find that the other party signed the contract, sent it to you via email, the signed copy, and then when you were then drafting, you then used it and you simply just printed it and attached it. But then now, in order for you to get the default judgment, you're then asked to sort of satisfy the requirements of ECTA. And that, for me, it's a bit confusing, because my understanding of ECTA would be that it has to be an electronically signed sort of a document, or a document that we did not have a physical copy of. But the only thing that I did was to simply print a copy. I do not have the original because the other party has the original. They simply just scanned it to me. Is it valid to to sort of have to rely on ACTA and satisfy that requirement on ACTA and on drafting the certificate?
Okay, you will only rely on ACTA if that certificate is called into question. Because, but it would stand you in good stead if you mention ACTA from the beginning, then it will take away all doubt, you know, or uncertainty from that moment on. And it will also be your disclaimer to protect you.
Okay.
Are you satisfied with my answer?
Not fully, but I think I understand what you're saying.
Yeah.
Yeah.
Rather err on the side of caution and include it rather than exclude it.
Okay. All right.
Yeah, I would say that.
Okay, thank you.
Pleasure, Nomtobek. All right, that was our last question. Please save whatever question you have for tomorrow. It's already 1 minute past our bedtime. I'm going to say good night to everyone now, and enjoy your evening. Have a fruitful day tomorrow, and we'll meet again tomorrow, same time, same place. Thank you.
Thanks,
Thank
Prof.
you, Advocate. Have a good evening.
Thank you, Advocate. Good night.
Thank you.
Thank you.
Thank you. Good night.
Good night, colleagues.
Good night, colleagues.